Laura, it's Nick. I just want to make sure you can hear me.
Hello.
Hi, Barbara.
Hey,
How are
Nick.
you?
That I can't really see. Your picture is so small.
I'm far
Yeah.
away, so yeah.
Yeah, Nick, I can hear you. It's Laura. How are you?
Hey, I'm good. Still waiting on the three that are coming here. So,
Okay, great. Thanks.
yep.
Hey everyone, this is Laura Arsenault. Just wanted to wait one more minute or two for everyone to show up. We'll start at about 6:35. Just give a shout if you have any questions. We're all sitting here. Thanks.
Hey, Laura, we're all situated here if you're ready to start. I don't know if you're waiting for someone else.
You can tell when my husband's coming as an observer, but he'll be here in a minute. You don't have to wait for him.
Hi, this is Laura. I think we're waiting for one or two more people. I was just going to give them one more minute and then I'm happy to start.
Might be him.
He knows it's a doorbell.
Be interesting to see what they say about the legal stuff with you here.
Well, she did. Did you see the email she sent? She said there were 2 documents on there. I printed one out.
Oh,
It's
today?
3 pages. Yeah.
Oh, I haven't seen it yet. No.
And then there's one that's like 50 pages, and I didn't bother with that one.
Can I take a look at it?
Sure. Hi, Mr. Stanges.
How you been, Velma Lee?
Page 3. Good.
Okay, thank you.
Real good.
Michael, this is Nick.
Hi,
My
Nick.
husband,
Hi,
Michael.
nice to meet you.
Nice to meet
He's the historian.
Okay.
you.
Unofficial.
You're the,
Oh, I
No,
thought you were the.
you-
Okay.
I'm an observer.
Okay.
All right, everybody, we're going to go ahead and get started. We have a lot to discuss tonight. So welcome, everyone, to today's Helen Hills Work Group meeting. It's about 6:35, and please feel free to message or chat if you have any questions or concerns. The chat will be recorded as well as the meeting. And Kira, my coworker, will be monitoring that and helping me regulate that. I will ask just a couple housekeeping things. If you're not speaking, please mute your microphone for less feedback. And I just wanted to do a little bit of a roll call and have a couple of our guests, just introduce you to a couple of our guests. So I'll start with the work group first. I'll start with the co-chairs. So Barbara, are you here? Barbara Ward?
Yes, I'm here.
Thank you, Barbara. And then Lee, I know you're in the, and then Millie, who's there? Lee, Millie? I can't tell. Mary and it's really small.
Michael.
Michael. Oh, hi, Mr. Sanders. Yeah,
Hi.
okay. Thank you. You're just really tiny. You're like a little super tiny. And then Nick's there too. Okay.
Buster. He's a spec.
So then I'll just go down my list for the rest, and just please just say that you're here. Andy Height.
Here.
Thanks, Andy. We have Elise Murray.
I wasn't unmuting. I am here, and as a reminder, I am the History Commission's longtime representative to the Architectural Review Board.
Thanks, Elise. Jerry Gibber.
Yes, here.
Thanks, Jerry. Kay Orr.
Here.
And then Kira's here. I saw her.
Yes, I am here.
Hey, Kira. Mr. Michael McGill.
Here.
Thank you. Bob Kinzer
Here.
and Ron McCallum. Ron, are you here?
I am here.
Hello.
Can you hear me?
Yes, we can hear you. I just unmuted you, but I'm going to mute you back until we start up again.
Okay.
And then wanted to do a quick introduction to our two guests that we have with us tonight. We have Ms. Cherie Halyard with the Office of the County Attorney, and she's going to be discussing some of the enabling legislation with us tonight. And then we also have Mr. Chris Daniel. He's the Vice Chair of the County Architectural Review Board, and he'll be talking with us, or talking with me, about the Arb process and some case studies that we've had. So we have a great group tonight. I will say we're not going to be talking about design guidelines tonight because the consultants are not here, and they wanted a little extra time to get some comments back and give you a new draft. We're hoping to have that to you by the 11th of November, which I understand is Veterans Day, but that'll be before the next work group meeting on the 16th of November. So we're going to take a little break from design guidelines, but if you have any comments or concerns, please feel free to forward them to me. But tonight we have some other things on the agenda. And also, if we have time at the end, I'm happy to open up that conversation again for comments and concerns. So is there any thing we wanted to bring up right at the beginning, or any comments or concerns from the work group?
Do you mean, may I ask a question about the regulations?
So we're going to start with, we're going to do our
I don't know. I'm responding to what you asked. Does anybody have anything to say?
Well, I mean, generally, let us do our presentation first, and then if you have any questions that are separate from that, then feel free at the end. I just meant
it's a real quick question.
Famous last words, but go ahead.
Is the Civic Association an aggrieved person for purposes of appealing an ARB decision? End of question.
Okay, I'll have to get back to you on that. It's not a quick answer for me.
Well, that's a legal answer, legal question.
Right, but I will say, I will caution that our county attorney is an attorney to the county, so therefore we cannot be giving legal advice. But anyway, she will not be giving you legal advice. But let me just go ahead and turn it over to Cherie. She's going to give us just a brief outline of the enabling legislation that allows the county to do a historic overlay district. So Cherie?
Good evening. Can everyone hear me?
Yes.
Hi, it's nice to see you all. I'm going to keep my camera off. I don't have a nifty office at home. I have one at the government center, so I will keep my microphone on. Good evening, everyone. Again, just to reintroduce myself, I'm Cherie Halyard. I am an assistant county attorney with the county attorney's office. And as Laura said, my role is to provide legal counsel to the board of supervisors and the county staff. I understand that there have been some questions, I think, posed to Laura by some members of the work group about enabling legislation, and I guess we heard one question already. So my goal tonight is to give everyone a brief overview of the enabling legislation. I don't know how much of this any of you have already investigated yourself or looked at it. So if I'm if I'm speaking about things that some of you already understand, just forgive me as I kind of give an overview to the entire group. But as Laura said, I always start these kind of public meetings with a caveat, which is that, with two caveats really. Because I represent the board and staff, what I can say in this public meeting that we're having is limited. I'm unable to give legal advice in a public setting to staff. I would do that, in a closed session or in order to ensure attorney-client privilege. And I'm unable to give legal advice on any private matters that might be bubbling out there that don't involve the county. So I just want to sort of throw that out there at the beginning. But to what we're going to talk about tonight, as I think there was some mention, you probably all received some attachments to an email that I'm going to use to talk about the enabling legislation. You received a copy of Virginia Code Section 15.2, I think it's 2306. And you also got a little bit larger document of the zoning ordinance. And I apologize for giving you 50 pages when you really only need to look at, I think it's part 2 of Article 7, which of course says historic overlay districts. So, okay, so to start, and I'll try to be as brief as possible. As many of you may know, because there might be I suspect there's some lawyers in the work group. Virginia is a Dillon rule state. And basically what that means is that the local governing bodies in Virginia, they only have the powers that are expressly granted by the General Assembly. They have powers that are necessarily or fairly implied by those expressly granted powers. And they have the powers that are essential and indispensable to those specific grants of authority. So that's kind of a long way of saying localities can only do what the General Assembly gives them express power to do. In that light, we are at the stage we're at because the Virginia General Assembly has granted localities the specific power to establish historic overlay districts, which is what we're all here for. And that is the enabling legislation is Virginia Code Section 15.2, 2306. As I said, that was probably I think that's the first attachment that you received. And of course, you all can read that, but I'll just give you a quick summary if you haven't read it. It says that any locality may adopt an ordinance setting forth any historic areas within the locality and areas of unique architectural value located within designated conservation, rehabilitation, or redevelopment districts. And they do that by amending the existing zoning ordinance and delineating one or more historic districts. So basically, that just sets forth the parameters of what a local historic overlay district ordinance would entail. One of the things that the enabling legislation provides is that for a review board to administer the ordinance, and I think we see that's where we get the ARB's role. And it also includes, among other things, a provision that no building or structure or sign can be built or altered within any historic district unless it's approved by the review board or on appeal by the governing body as being architecturally compatible with the historic landmarks, buildings, or structures therein. So there's all these sort of magic words, but you get the idea, okay? Subsection C of the enabling legislation talks directly about the establishment or expansion of a local historic district and what a local ordinance has to include, which is identifying and inventorying the landmarks, the structures. It also says that before any ordinance is adopted by a locality that would establish an historic overlay district, that locality has to provide for public input from the community and affected property owners, and that is done by way of a public hearing before the Planning Commission and the Board of Supervisors. In addition, the enabling legislation also establishes that written criteria can be used to determine which properties should be included in the historic overlay district. It also says that localities are to review the inventory and criteria, and they also are to establish the boundaries, and you can exclude properties from those boundaries that don't meet the criteria. Based on this enabling legislation, the board has enacted zoning ordinance, Article 7, Part 2, which again is a portion of that larger document I sent. Both of these things are for you to keep and circulate. They're public documents, so there's for you to, and those are our guiding principles, or staff's guiding principles as they go through this process of evaluating whether the Hollin Hills should be a historic overlay district. So in the zoning ordinance, hold on one second, I have a Word document I'm following here. Okay, so the zoning ordinance sets forth in detail the purpose and intent of a historic overlay district. That's section 7201. Again, it talks about the public good for identifying buildings, structures, neighborhoods, landscapes, places, areas that have special historical, cultural, architectural, or archaeological significance as provided by the enabling legislation. And it goes on to list all those purposes. I won't bore you with reading. You can all read that. The next section talks about district boundaries. It describes how the areas, talks about describing the areas that are to be preserved, how to include properties that are adjacent and contribute to the historic value. Section 7203 talks about how to establish a district. And I guess that's kind of where you all are right now in terms of your, and staff's, where staff is in terms of the effort to create and establish a historic overlay district, and that's what the work group here, you all's combined goal is to do, and so that's where we are. And so you can see in 7203, there's a lot of talks about how the Board of Supervisors makes the determination that an area possesses these historic, architectural, archaeological, and cultural significance. To determine that significance, the property or the properties comprising the district must meet one or more of the following criteria. And you see a list of there, and there's, I think, 10 enumerated criteria there that the board would have to ultimately decide exists. One of which that might be related to this effort is, I think, we have criteria F that talks about representing the work of a master craftsman, architect, designer, or builder. But any of those can be met, one or more. Next, it talks about the same establishment of an HOD. Says that the Department of Planning and Development, along with the ARB and the Fairfax County History Commission, shall prepare and submit a report to the Planning Commission and the board evaluating the proposal. And that report was going to identify the boundaries, historic significance, et cetera, to be protected. And it shall include specific information. So whenever you see any ordinance that says shall, that means it's a requirement. So they'll have, that report has to include specific information such as the current condition of the area, descriptions of the structures, boundaries, recommendations regarding the regulations that have to be applied, such as use limitations that relate to size requirements, exterior character, et cetera. If the board ultimately determines that it wants to establish the historic overlay district, and the zoning map is amended, and it overlays, as the term says, kind of implies, it overlays the existing zoning district that it's located in. So the underlying zoning regulations will remain, unless they're expressly modified by the regulations of the specific historic overlay district. The zoning ordinance goes on then once an HOD is established. So if the Hollin Hills HOD were to be established, it sets forth sort of the parameters, requirements about administering the administration of the HOD. So for example, all rezonings, special permits, special exceptions, variances, sign and building permits, site plans, grading plans, those kind of things must be referred to the Architectural Review Board for its review and recommendation or decision. I don't want to steal Mr. Daniel's thunder. I know we have our next speaker is going to talk about the Arb process, so can talk about it in more detail. But here is where there's a lot of provisions that talk about the Arb review and recommendation, including consideration of potential impact on these applications on historical, architectural, archaeological significance. The zoning ordinance here lists numerous considerations that the ARB has to undertake, including impact of the use, change to the visual character of the district, other factors. So for example, the ARB's approval is required before a building permit or a sign permit is issued. The ARB approval is not required for the issuance of a building permit for certain enumerated things such as interior work, roofing, residing, where the color, material, texture is similar, for example. It sets forth the ARB procedures to follow when reviewing building permits. It requires the building ARB to review building permits to raise or demolish or relocate structures. ARB has to, hold on. My Word document jumps on me, I apologize. The ARB approves or disapproves modifications, proposed modifications. It formulates and adopts guidelines for new construction and exterior alterations of existing buildings in an HOD based on specific standards in the zoning ordinance. And this might go to the question I think Mr. McCallum raised. It says anyone who is aggrieved by the ARB decision can appeal it to the board, which reviews the ARB decision. That decision can be appealed, and that decision can be appealed to circuit court. Who an aggrieved party is it says anyone who is aggrieved. So it really kind of goes to what the definition of aggrieved is. But
it sounds like an aggrieved person. Is a person, can that be a corporation, or does it have to be a live human being?
It can be an entity. It can be aggrieved usually is not just limited to a live person. But there's issues once if that were to happen, especially if it gets to circuit court, that a group or a person who believes they're aggrieved still has to prove standing and things like that. Yeah.
I understand.
Right. The ordinance goes on to talk about, I think we're still talking about, the ARB. No building or structure can be erected, built, reconstructed, moved, externally remodeled, or altered within an HOD unless it's approved by the ARB as being architecture compatible. I think I said that already. I did, so I won't repeat myself. Section 7205 mentions permitted uses. So within an HOD, all uses that are permitted by the underlying zoning district are permitted, except any zoning regulations that are modified by the HOD regulations. And that's same for use limitations as well. That's basically it. You have the language there, you have the enabling legislation. That's what drives our efforts and the county's efforts. We are required to follow this because this is the authority given to the locality. And so this is kind of the marching orders to follow as this process is undertaken. So that is basically the end of my presentation. I don't know if there are any questions about the enabling legislation. I can see if I can answer or not answer.
Yeah, this is Mike McGill. Question, opening statement. Or from what you said, it sounds as if Virginia does not allow cities to achieve or counties to achieve home rule status.
I don't know what you mean by that. I don't know if I can answer that. I mean,
it means they get great autonomy over their.
Oh, I see what you're. Okay. I think you're talking about when I was talking about the Dillon rule. So
yeah.
So yes. Okay, I understand your question now. I'm sorry. That's right. I mean, Virginia's a Dillon rule state. So I often tell people if they are frustrated with what a zoning ordinance allows the county to do or not do, my first piece of advice is then you are welcome to lobby your state legislatures to amend either amend the enabling legislation or even lobby the board to change the law. But yeah, we only get to do what the General Assembly lets us do. So yes, for better, for worse.
This is Barbara Ward. I have a question that I had raised previously.
Okay.
Can you tell me if there is a statutory or regulatory requirement that the Secretary of Interior criteria for historic districts must be used in order to draw up the guidelines governing the historical overlay district?
I think my answer to you to that is that requirement is not set out in the enabling legislation and it's not set out in the zoning ordinance. So my answer to your question is, if it's not in the enabling legislation as a requirement, then that requirement doesn't exist. Now, whether or not that consideration can be made by staff if they want to, that's a choice, but it's not a requirement.
Three, let me just clarify too that in the zoning ordinance, some of the Secretary of Interior standards are quote unquote summarized. And so they didn't quote them from using the Secretary of Interior standard, but they are summarized as part of the, and that's one of the changes we're making with ZMOD actually, is to reference the Secretary of Interior standard. But there are specific, it doesn't say specific, you're correct, it doesn't say specifically Secretary of Interior standard, but it does call out some of the principles that are in that document.
Is that in the enabling legislation, Laura, or in the zoning ordinance?
That's in the zoning ordinance, and I'll find it and put it out to you. Hold on one second, it'll just take me a minute.
Okay, that's good to know.
If you want to go ahead and
if
there's any other questions.
I didn't know if we were waiting for you. Okay.
Hey, Laura.
Yes.
Laura, it is at page 7-14 through 7-15.
Yep. I just pulled it up.
This is Chris Daniel, the vice chairman of the ARB.
Okay.
Thanks, Chris.
Okay.
Yeah,
so that they would know more than I would know the answer to that question. So I'm glad you were able.
Well, but yeah. So this is so two things is it's summarized in the zoning ordinance. So this 7A through, I think it's L. So we have some Secretary of Interior standards, and I think we talked about it at the ARB meeting a couple months ago, is that we have some landscape architect standards. So it's not specifically just a Secretary of Interior standard. So it's summarized in like kind of a pick list of things that the county wanted to include, but the underlying intent was to do the Secretary of Interior standard. So
give that site again, Laura?
I'm sorry?
Can you give that site in the zoning ordinance again that refers to the Secretary of Interior standards?
It's a section right here. It's on page 7-14 of that 50-page document that you got, and I think it's 720. Oh,
I see. Okay, page 7-14. Okay, that's all right.
Yeah, number 7, and then it's A through K, I think.
Okay.
Or I'm sorry, L. So those
are. Okay. So those are the Secretary of Interior standards.
Yes, the first couple are, and it's not word for word, but the intent is the same. So because it's industry practice to use the Secretary of Interior standard when we're doing rehabilitation or modification of structures. So that's how they were kind of folded in here. But we just thought that made it really confusing for everybody else. So that's what we're trying to change. I think we're trying to change with the zoning ordinance. But to your point, Barbara, I want to make they are in there, but I want to just make sure that I follow up and that, this is what the ARB says. The ARB will formulate and adopt guidelines for the new construction for the exterior alteration. And that part is that part is meant to be the Secretary. So that's what the ARB is using to adopt the guidelines, and what should be in the guidelines is the Secretary of Interior standard. So it's a roundabout way to your answer, but it is in the zoning ordinance, which would be the statute, not statute, but the
ordinance the
ordinance, the regulations that we'd be following to write the guidelines.
Okay, thank you.
So that's clear as mud, I'm sure, but yes.
Well, oftentimes when these things get drafted, there's decisions made about how specific. So I just learned something myself today. So I'm glad the question was asked.
That's something. I mean, that's something we learned with the zoning modification process too. That we were like, hey, we need to make this clearer, so it's everybody in the preservation field knows what it is. But were there any other questions? Sorry, was there somebody else?
Lee has a question.
Yeah,
I'm sorry, Lee.
This a clarification and a small one. I've heard the word sign used several times.
Yes.
We have sometimes in our neighborhood, we have tricky curves and hills where it's a concern when people are speeding and children, and we put up various signs to slow down or be cautious for children. How does that apply? I mean, are you talking about permanent signs permanently affixed signs or free kitten signs? What's the scope of signs?
I'll
Well-
take the free kittens. No, I'm kidding. Go ahead, Sherry.
Right. No, I mean, the sign ordinance is part of the zoning ordinance, and that is applies. So any rules about signs would have to abide by our sign regulations. But obviously with the historic overlay district, because the ordinance talks about approval from the ARB for any alterations to signs. I mean, I don't.
It would be, I'm sorry, Sherry, I'm jumping
Yeah.
in, but it would
Jump
be
in. No, go ahead.
whatever, it would be whatever would require a sign permit. So we're talking
Yeah.
more commercial signs. We're talking like building mounted signs or post signs, more along Route 1, what you're used to seeing there. We're not talking about temporary signs, for sale signs. All those signs
Okay.
are temporary, and yeah,
Mhm.
not expressly, but it's a by right use on the property. That those signs are
Right.
temporary signs. They don't require a building permit. But yeah, I'm talking the Safe Kid sign, the Free Kittens, the Home for Sale.
Right.
Those
Right.
are all permitted because they're temporary signs.
But that would apply to the Hollin Hills entry signs.
Correct. Right. So that, the Hollin Hills entry sign, or, like I said, it wouldn't be very common in this area if you had a sign. Like, for example, you can't have a sign if you have a home child care on your property. That's just one of the regulations. So we're trying to limit the amount of signage that require permits, in those districts. So I'm not sure if it's even allowed in a residential. Anyway, I have to look it up. But the underlying is that it'd be more commercial signage, what you would need a building permit for signs.
Right. That's right.
Were there any other questions?
You can give away those kittens. You've got it.
Right? You don't need a sign.
Go to it.
Kittens don't last long.
No.
Okay. Thank you, Cherie. If you have any are there any other before we let Cherie go? I know she's got other things she's got to go to.
I mean, if you have any other questions, you feel free to shoot them through Laura. And if I can answer them, I will happily answer them. And if I can't, I will try to do my best to tell you why I can't. But yeah, otherwise, it was nice talking to you all this evening.
Great. All right, thank you, Cherie. Appreciate your time.
Thank
Laura,
you.
he has a question.
Yes, Lee.
Oh.
Yes, Lee.
Yeah, I have a question. It's what I emailed you about the other day, Laura, and I'm not sure who to ask it to or who would be the appropriate person to provide some input into it. I am concerned, I always get concerned when there's several contracts that integrate with one another. All right, and I'm concerned about how that's going to affect the individual homeowner here, not the legalities of the HOD, that kind of thing. And we have contracts for insurance inspections, mortgage requirements for maintenance, and mortgage requirement for insurance. And then we have verbiage in the code, the Virginia code, particularly 15.2, the preservation of historical sites, and the authority to force repair. 15.2906, the authority to require removal, repair of buildings and other structures. I'm confused how those things are going to integrate and how a homeowner could get tied into or grabbed by that net of integration of contracts. Because under certain circumstances, the county can require repair, okay, and removal. And then there are the requirements for the insurance company with an AVID house. We've been lucky, for the most part, I've been lucky. I never had to have an insurance inspection. I would be concerned if I was to have one because my house is now part of an HOD. And my insurer, for instance, would require one if they learned that I was then part of an HOD. And we have some serious issues that the insurance inspection, which I sent you an overview of, looks for, that could cost people a lot of money and a lot of concern. So I don't know how that all integrates, but I'm concerned about how individual homeowners, can get trapped by the integration of all of those requirements. Is that clear?
Excuse me, are you saying that I want to make sure I understand your question, Lee. Are you saying that you're concerned that insurance contracts will be impacted because of our HOD status?
Yes, ma'am.
And what is your basis for saying that?
I can refer you to the email that I gave to Laura, which is, let's see, home insurance inspection. Okay, it tells you what a home insurance inspection is, all right, and what it entails, and when it might be required, and the fact that insurance companies have up to 90 days after a policy on a new house is written to make that requirement, and what they look for. And they look for things, structural things. They look for things.
Well, how is that impacted by, how does us becoming an HOD status change that?
Barbara, I'm already on the path to get her an answer, to get Lee an answer for this. So I need to consult some other groups and some realtors, possibly with the county, to try to get an answer. But because it's a private issue, I don't know how far I'm going to get, but I'm on it. I just haven't been able to get there yet. So I will come back with some clarification.
We've lost you, Laura.
I know. I see that. My video.
I don't know what you did.
Okay. I'll come. Can you still hear me?
I can hear you clearly. Yeah.
Okay. It's just the video. Okay. I don't know. I'll stop sharing. I'll not shut it down, but I'll stop. Probably my kids are on Netflix now. Let's see. Yeah, I'm trying. Anyway, Kira, would you mind? I mean, we can keep asking Sheree questions. Go ahead, and I'll try to fix it unless we're done with that, and then we can move on to the PowerPoint presentation. If not, but I am on a quest to find an answer to your question. I just wasn't able to get to it today. I'm sorry, get to it before today. All right, I'm still frozen. All right, I'm going to go away for a second and come right back. But thank you, Sheree, for coming tonight, and I'll be right back, hopefully.
Laura, you are now logged in twice.
Oh, good. Fun for me. Let me see if it goes away. Last time this happened, I went away, my old one ran away, but let's see, because I had to. See if I can kick my old self out. I'm still presenting. Sorry, everyone. Okay, I think my other one went away, right?
You are.
It appears so.
Okay. There's only one of me, I'm sure. Right now. Okay. All right. So let me, and as Sheree said, if you have any questions about that, please let me know. Lee, like I said, I'm on it. I'm on your question. I just haven't gotten a chance to get to the right people, but I'm in a fact-finding mission. But if you have any other legal questions, we have the county attorney at our disposal that I can kind of ask and try to see if we can get an answer. So if we are good with that, I'm going to move on to kind of an overview of the ARB procedure, because I think from the last meeting that we were all at, I think we needed to kind of come back and have a refresher on all of the procedures that the ARB does and how the design guidelines come into play, where and if they come into play, and then how, you know, the homeowner would use it versus how the ARB member would use it. And that's what I'm hoping to get through tonight. So I have, as I said at the beginning, I have Mr. Chris Daniel with us. He's the vice chair. And Chris, I don't really have a spot for you to jump in, so just feel free if you feel like you can add anything. But I'm just going to go through the ARB process, and then I have a case study at the end of a deck that was in another historical overlay district from beginning to end, so you can kind of see step by step of what the applicant went through the ARB. So this is just for building permit process. The site plan, well, the site plan is with it, but the building process is probably what you're going to come into most. Building permit would be for any.
Hey, Laura.
Yes.
Do you have a presentation that's showing?
I do. Thank you.
While Laura pulls it up real quick, since I don't believe any of you have ever met me before, potentially, except for the few folks that are county. My name, again, as Laura said, is Chris Daniel. I'm the vice chairman of the Architectural Review Board. Just a little bit of background about me. I am an architectural historian by trade. I work for the Advisory Council on Historic Preservation. It is a small independent federal agency that advises the President and Congress on preservation initiatives across the country, as well as provides guidance to federal agencies as they make actions that may affect historic properties, which is formally called the 106 process. So my background comes in buildings, but I am a jack of all, an expert of none, I would say. So that's part of the reason why I fill one of the very interesting roles in the ARB, because I'm not an architect, I'm not a lawyer. I have a background appreciation of architecture and applying standards, but not someone who could actually do the designs themselves. Also, since I have been on the board for quite a while now, Laura thought it'd be a great way for me to chime in periodically for this to kind of give the perspective on how the ARB operates with applications coming in. And I think just before she kicks off, I think one of the big things I want to always like to emphasize is that it's not the ARB's job to say no. It's our job to understand what an applicant wants to accomplish and to work with them to achieve their needs while respecting the character and the integrity of the property, as well as the larger historic overlay district. So we're not, I don't ever want to give the impression that we are just a group of individuals that just all say nay all the time. We are meant to be there to work with the applicants that come to us that have historic overlay districts and find solutions to their challenges that obviously keep into account the respecting the properties within them. That's just my little prelude that I've given quite a few times, but I'll turn it back over to Laura. And Laura, I'll just chime in whenever, if that's okay with you.
Feel free. I'll give you a couple seconds after my spiel. But I also want to say, too, that we do have 3 other members of the ARB on our work group that you've met before, and I just want to give them a quick shout out so you know that you can come to either them or me or Chris with any questions that you have. So it's Kay Orr, and then Jason Zellman, who's not here tonight. But then we also have Elise Murray, as she stated at the beginning, who's the liaison to the ARB, and Elise, you can correct me, it's the History Commission liaison to the ARB, I believe. So, but yes, those are we have a third of our ARB team here tonight, so that's pretty impressive. We almost have a quorum. But here we go. So can you see my PowerPoint now, everyone? Okay, great. Thank you, Chris. So the first step is to apply for a building permit or a site plan at the county, and that goes to the normal county procedures. And I'll go in depth of each step in a minute. And then from that step, you would consult with Heritage Resources staff for review. So that's myself and Nicole and Kira. And then at that point, we would determine whether or not you needed to go to the ARB for a full review. Then you would, if you do, you need to come to the ARB. We would ask you for a submission application, which includes a bunch of forms, maps, and your permit plans or site plans as appropriate. And then you would have your formal ARB review meeting, and that would be in the shape of 2 meetings, which is a workshop and an action item, which I'll get to in a second as well. And then after that, there's one more final check for conformance that Heritage Resource staff does after the final permit is submitted and the ARB approves it. Sometimes because there's 5 or 6 months that goes through before when the ARB reviews it, and then it ultimately gets submitted for permit or site plans. And then the building permit or the site plan would be approved through the normal process. So those are the quick quick and dirty 6 steps that we have. So I'll go into them a little bit more. Let's see if I can get it to work.
Can I ask about step 2?
I'm gonna go into detail. So just give me 1 minute, and then when we get there, why can't I?
I thought you'd been through step 2.
Well, I have a slide for each. I have a slide for each step. So that was just your overview. So the county process, as I mentioned, is for the ARB. It only requires building permit, site plans, and as we learned earlier tonight, sign plans, but they're not really relevant to the Hollin Hills HOD. But those permits would be submitted through the Land Development Services and our Permit Action Center through the normal county process. And right now it's all an electronic submission online. So building permits, including demolition for the ARB, building permits, including demolition, require ARB approval. So that would be decks, additions, anything that will rise the level of building permits. And then the site plans are only ARB recommendations are needed. So for example, if you're putting in a pool and it requires a site plan, then that would be something, if it disturbs more than 2,500 square feet, that would rise to the level of a site plan and then ARB approval. So then step 2, it comes to staff. Usually the building permit reviewer sends it, or the site plan reviewer sends it to our staff. And then we make a decision on whether or not it can be approved administratively by staff, or if it needs the full ARB presentation. There's a third step that we can waive it, and it's not an HOD, but usually we have map triggers that, and GIS triggers that say whether or not it's in a historic overlay district. So the ways that it can be approved administratively by staff are in this kind of pink box there to the right, but they're only for building permits only. So we can admin approve it if the building permits are interior renovations only. So if something happens interior of the house and there's no changes on the exterior, we can administratively approve it. If the modifications are not visible from a major thoroughfare, so that would be Fort Hunt Road or Sherwood Hall Lane, or roads that are listed or eligible for the National Register. So that would be the interior Hollin Hills roads as they are now, because of the fact they're already on the National Register. And then a contributing or historic property. So it severely limits.
Is somebody unmuted?
I don't know.
Because I'm hearing weird sound.
Thank you, Elise. I will check. Okay, there we go. A little bit better. Okay, so staff can only approve the modifications if they're not visible from one of those 3 things. The other things we can administratively approve it for is re-roofing or re-siding of non-contributing structures or previously approved site plans, which once again don't really apply to this area. So those are kind of the stages that we go through of, do we have to review it? Number 1, is it in a historic overlay district? Number 2, can staff administratively approve it without it rising to the level of the Architecture Review Board? And those are express powers allowed to us in the zoning ordinance, and I have the link at the bottom. And I'll post the PowerPoint on the website when we're finished tonight. And then if it is a contributing property or a historic property, or if it is visible from a major thoroughfare, then it would rise to the level of an ARB review, and therefore we'd have to take it forth to the ARB. So, yes, I'm sorry. I know Ron had a question too on this one.
Just a quick question.
Is this Millie? Sorry.
Yeah, it's Millie. Sorry.
I know. It's okay.
I was under the impression from all our meetings that the historic overlay would not have anything to do with any interior work on the home. And I think I heard you just say that if there was a permit, like people are supposed to get but often don't, but if you get a permit because you're doing a renovation on the interior and you're changing your kitchen, and so you need a permit for that, you're saying that you need to administrative fashion approve what's going on the inside of my home?
Because it says so in the zoning ordinance. Right now, as the zoning ordinance written, it says it doesn't need full ARB review if it has interior alterations. So in the new version of the zoning ordinance, we've struck the interior alterations entirely, but we're not to the new one yet, which will be released next year. But we understand it's kind of, the ARB has no jurisdiction over the inside of the properties. And I don't know how this got in the zoning ordinance, but basically if it's, right. So, but basically the ARB has no purview over the interior. So we just administratively approve it. For example, we had a bunch of properties in Lorton, new single family houses that got built, and they had a permit issue because of the interior insulation in the attic. And because it was an interior approval, we had to approve them administratively, but we didn't have to send them to the full ARB. So the difference is that you're just having staff administratively approve it, and we recognize that. You wouldn't have to, it's like a quick 1 day, maybe 2 day turnaround that we would just approve it and sign off on it and move on, as opposed to going to the full ARB, which you have to go to the public hearing or the public meeting and then wait for their decision. So as the zoning ordinance stands now.
I'm just observing that this is completely different than what we were told all the meetings.
Well, I'm telling you that the zoning ordinance modifications, we recognize that there's conflicting information, and so we're taking it out. So if it came in today, all the ones that come in for interior modifications today, it's just administratively approved by our staff. There's no ARB, formal ARB process or anything with that. It just happens to come to us because it gets triggered for review. We review it, make sure there's no exterior modifications, and then approve it. So it's a much simpler admin thing, but we recognize that it doesn't meet what the guidelines
Laura?
are. Yes, Chris.
This is Chris. I think it's important to point out that you're only doing this because there's a building permit going for the county. It's not that someone is coming to you for it. It's that the building permit process the county has is sending them to the ARB. And as an ARB member, we're grateful that Laura and them do that because we, as she pointed out, one, we have no purview, and we don't desire to see those types of applications because it doesn't make any sense. But what you're saying is that the building permit process in the county is requiring them to come to you. It's not that someone is individually coming to the ARB admin staff, but that the building permit process is requiring that admin review by you.
Right. But not to beat a dead horse. If you're renovating a house and you're not in an historic overlay district, none of that happens. If you have an internal permit, at the end of the job, an inspector comes and very quickly runs through, and that's it.
There are different inspectors for interior alterations through the county. So that's, but the ARB has no purview over that. So that's where the difference is that we're only reviewing the exterior modifications in a property that's identified in the historic overlay district.
I'd like to give it a try.
Okay.
Is that okay?
Yeah, sure.
Yeah, you pretty much answered most of my question, but let me just try one more approach, and that is when you approve something administratively, and then I look in the regulation, I think you call the regulation an ordinance, it says that the ARB shall approve, modify, or not approve. Now, is that when you administratively let something not go to the full ARB, does that mean the administrative record, the entire record of the building permit, et cetera, contains no mention of the ARB?
No, the zoning ordinance gives staff the administrative power to approve those on behalf of the ARB because of the fact they're called out that we have to, as Chris Daniel said, that we have to review them due to the building permit process with the county, but the ARB has designated us and the Board of Supervisors has designated through the zoning ordinance the things that we do not have to rise to the level of the ARB, but still require a legal sign off from them.
So that designation somewhere exists somewhere?
Yes, so there's a building permit. Yeah, there's a building permit database called FIDO, and I think it's something inspections database online. But basically, I do I would sign off on it in that, and I would say in, admin approval with staff, admin staff approval or something like that. So they would know that the ARB, and that goes in the record, the permanent record for that building permit.
I totally understand that you feel competent to just let something not go to the ARB, but I came from a world in which the administrative record is important. And if there's no reference to the ARB, or there's no decision by the ARB to approve, modify, or disapprove something, something is missing from the record.
No, so we're not, this is only staff approval of cases that don't go through the full ARB. So the
I understand. That's the problem.
So for the second one, there's a
Maybe
separate.
Christopher can answer.
I'm not quite sure if I'm understanding what you're asking, if only because the ordinance for the ARB lists the items Laura has provided here as things that the ARB does not have to review. However, the county's building permit process has created a scenario in which she bureaucratically has to point out that we do not review these items.
So there's something in writing somewhere that says you don't have to.
I want to chime in, Ron. There is an administrative record. Laura's sign-off becomes part of the building permit record, designated as a staff sign-off. It's documented.
Yeah, I was just simply trying to connect the dots between a regulation that says that the ARB does something and administrative approval. And I guess Christopher is saying there is something in writing somewhere that says it doesn't have to go to the ARB.
So in the zoning ordinance for the ARB in 700-204, the document that the lawyer was wonderfully quoting from earlier, there's actually a specific item starting on page 7-11 and ending on page 7-12 that describes ARB approval shall not be required prior to issuance of building permits for the following. And it lists the 4 items that Laura has described here on the screen.
Oh, great. Okay, that's the answer as far as I'm concerned.
Frustratingly, though, as Laura's pointed out, the county's building permit process still brings said permits to her, and she then has to approve them through their record system saying the ARB does not review these, basically.
Okay.
Did I get it right, Laura?
Yeah, the link's at the bottom of the page too with the zoning ordinance reference. So that's a full zoning ordinance part there. It'll be the same section that Cherie sent to you earlier. That's 50 page, but it's the 7204 A through D, and it's very muddy right now in the zoning ordinance, which is why we're modifying the language with our separate zoning modification process. But for right now, this is what we have that we're trying to charge to do with the building permit review. So,
Laura?
Yes. I don't know who's talking.
Number
Sorry.
2, modifications not visible. Oh.
Yes.
Yes. Go. You're saying go? Talk?
Yes. Yes. I'm sorry. Yes.
Okay, number 2, modifications not visible for major thoroughfares. Example, for a road. What that makes me think is, okay, I've got an idea to expand my house. All right, and I have plans, and I have it drawn up, and it is not going to be taller than the front of my house, and it's going to extend to the back of my house. And it's nowhere near Fort Hunt Road. It's on Rebecca Drive, which is one of the side streets in the community. And I could get a administrative approval from without the full review of the ARB. However, if my neighbor, for whatever reason, jealousy over improvements or whatever reason, wants to take challenge to that through the subdivision deed, all right, and claims that they have standing and they don't like the line of sight invasion that they claim my addition would cause, then now I'm caught in the middle again. I've got ARB approval, All right, but then I've got a descending neighbor who wants to stickler me on the contract of the deed.
It is also highly, this is Kira. It's also dependent on whether or not the property is contributing or not or visible from a contributing property. And that's what makes Hollin Hills very tricky because there is multiple properties.
You covered that in the past, okay? And that's what I wanted to clarify. Does this override that? No. Okay.
No, this does not override that.
Right to claim line of sight objections, is what you're saying.
Correct.
Even if I got a provisional or an administrative approval from the ARB to get a county permit.
Yes. If that was the case, if it was not visible from, and usually we would do this through a Google site visit because of the fact I can't go out to everyone that comes into the county. But we usually, go do Google site visit, aerial views, topography checks, LiDAR, things like that to check and see if there's a view shed impact. But it also talks about if it's road listed or eligible, so most of the roads will be visible, but it depends on where your addition would go. For example, if you're putting addition on the back, like you said, and it wasn't visible from a major thoroughfare or from a contributing or historic property, well, if all the properties around you are contributing, then you would still have to come to the ARB. So if it would be adjacent or from the property, you'd have to come and see it. You'd have to come to the ARB.
Tough.
So I guess I could do anything because I'm surrounded by non-contributing properties.
Go crazy.
Hmm?
Go crazy.
So,
No matter, most of the time it doesn't matter.
so were there any other questions based on this step 2? Okay. So then if you need to go to the ARB, get my PowerPoint working again. There we go. If you need to go to the ARB, there's an application form that you'd have to fill out. It's just a very preliminary, who you are, contact information, address, location. We'd ask you to print out the map of the Historic Overlay District. This is a map of Centerville Historic Overlay District. And then you'd want to have your site and grading plan that should say site and grading plan and building permits, either one, whichever you're proposing. And then you'd want to have some architectural drawings, possibly including elevations and floor plans, and then photographs of the property and adjacent land for development. Now, I will say with most of this, it's already information that you're applying for and that you have to include your building permit submission. So you would just be kind of pulling pages from that submission to send to myself and the ARB. And usually the 2 things that you would have, or 3 things you'd have to do is the application form, the map with the location, and then photographs of the subject property. And usually we ask for I usually ask for a cover letter as well to kind of help you justify the reasons why you're asking for the addition or the deck or why you need to have the modification.
And Laura, this is Mike McGill. These are very similar to what the Design Review Committee requests when plans are submitted to it.
Right. Mm-hmm. This is in the zoning ordinance as well of what we ask that you submit for the ARB submission. Are there any questions on that? So then this is the ARB review and presentation. And Chris, if you want, I'll just start and then you can jump in when I'm done, or if you wanted to add a couple things. So then you go to the presentations before the ARB, and we usually ask for a summary, presentation, a PowerPoint, something like that to provide some visuals. In the past, we've had some, you can bring displays with you, materials, but the person that presents can be the homeowner, it can be the architect, you can have an agent for you, it can be the engineer, or whoever's working on your building permits. We do recommend that there's 2 presentations before the ARB, especially if it's a complicated issue. We have something called a workshop item versus action item. So the workshop item is for discussion only, and I call it kind of a feasibility discussion of, what do you think of this project? Here's what I'm proposing. Here are my different options. and then you get preliminary ARB comments and concerns and feedback. And we do recommend that most of them, if not all, the projects come for a workshop. And then the second meeting you would come to is an action item where you're looking for an approval, denial, deferral of the building permit or site plan. So once again, let me just clarify that the approval is only for building permits and the site plan is for recommendation from the ARB. And then and when you come as an action item, it doesn't mean it has to be final, but if there's some modifications we need to make, usually it's, materials, brick color, paint color, things like that, something very minor that can change and that I can bring forth with the approval when it comes back in. So Chris, did you have anything else you wanted to add on that?
Sure, I'd be glad to chime in a few points. So Laura mentioned the workshop session versus the action item. Obviously, it's not a requirement for any applicant to come in as a workshop session, but we've learned that with more complicated projects, that coming in for a workshop session can be very helpful because it allows the applicant a chance to kind of discuss their ideas in a more informal setting, as opposed to bringing something in with the expectation that it's going to be approved, denied, or deferred. And so there's a lot more riding on that. Obviously, we encourage folks to come in even sooner than, needing the building permit just a little down the line, that they can do a workshop session, because that means more likely that they're going to get something through in the next session. This is a very common practice for a lot of different design review boards, not just in Virginia, but across the country, for providing this opportunity. Another thing that the ARB has done occasionally is provide member support to applicants. So if there's an applicant that's struggling with an issue, we actually can put them in contact with one of our members if they have the ability to do so and provide some perspective, not speaking on behalf of the board, but their expertise, because we do have at this current point 4 architects, an architectural historian, a landscape architect, an attorney, as well as some other subject matter experts in the past. We've had an engineer in the past. So the board is meant to provide a diversity of backgrounds, so that when we're looking at something, you're hearing from all different perspectives in the locus of how is this affecting the historic overlay district. Another thing I'd like to point out, that the thing that we do frequently see things get bogged down in is lack of detail and specificity on things. Laura is right that things that we add conditions to frequently are about materials, colors, or trying to understand the actual makeup of materials when they're doing things to a structure or changing a material, particularly when you're dealing with things that are getting older in age. A lot of the districts that the county has obviously are fairly old in the types of properties in them. So some of the materials aren't made anymore, or they're not made anymore because of what's in them is no longer safe. And so we have to work and understand whether or not a replacement material is acceptable and whether or not it meets those standards that Laura talked about. And I think this is a good chance for me to just chime in about the Secretary of the Interior standards, which is a set of standards that was put together by the Department of Interior under the Park Service. They were done as part of the National Historic Preservation Act, which was a federal initiative to improve how the federal government took care of properties, and became the kind of the gold standard for consideration of how you treat historic properties, looking at it from 4 different perspectives: preservation, rehabilitation, reconstruction, or restoration. Most projects stick into the one called rehabilitation, which is, reusing and utilizing the existing structure, obviously not being able to necessarily always maintain materials in perfect preservation, which is just keeping things exactly as they are. Reconstruction and restoration are trying to bring things back either from non-existence or from things that have been damaged in the past. But the ARB relies on those because they're not only the basis for the federal government, but the state Virginia Department of Historic Resources utilizes that. The eligibility standards that were used to determine if properties are eligible for the National Register are also based in those same mindset. And so even tax credits utilize those standards. So that's part of the reason why we integrated those into the zoning ordinance, because they really are a set of measured approaches to looking at how you treat a historic property.
This is Elise, I'd like to chime in at this point that ARB almost never denies applications. What we usually do is ask that they be deferred. If the applicant is expresses a willingness to go back and do some more work on the application, We defer, and that's what happens most of the time. The applicant is almost always willing to take another shot at it.
Elise is definitely correct. I don't think we've ever actually been involved in a situation which we've completely denied a permit. We've actually had a deferred review and had the applicant come back to us. We've always found a way to problem solve the solution of the needs of the applicant with the needs of the property involved in a way that works, in our mind, we think successfully. And we've seen quite a few challenges involving properties that what the applicant came in wanting to do with the property, we would have never thought we would have found a solution, but we somehow were able to do so.
Great. Thank you, Chris and Elise. Were there any questions? We can have questions at the end too, but was there any clarification?
Yes, excuse me. This is Bob Kinzer. One of the problems I see in this is very fundamental, and that is that when you go to get a building permit, you're almost completely committed to what you've got on paper, and you put money into drawings and all sorts of things, and a lot of emotion as well. And that's where I would hope that our design review committee in Hollin Hills would become part of that in preparation for going to the ARB and for getting a building permit. Otherwise, you have people coming in ready to build, basically, without having ever necessarily been made aware of our design review requirements. So it becomes a problem for us as a community and for the homeowner as a real problem for them, possibly, in terms of getting it approved. So my question is basically, how do you get the workshop approach when you only are looking at things that are asking for a building permit already? It sounds like I would think you would never get a workshop situation without having caused somebody a lot of pain.
So Laura, I'll let you chime in too, but I will say not all applicants that come to us for a workshop session have a building permit yet asked for. They come to us early in that process, recognizing that ARB approval is going to be required. And rather than going through the process of putting designs together and getting a architect on board or a landscape architect, they come in advance. And the important thing to point out, Laura talked about submission requirements to the ARB. The action item has very strict submission requirements to make sure those materials are there so that we can make a fair and valued assessment of the proposed action. At a workshop session, we've had applicants come in with merely just pictures of things they're considering, photographs of existing site conditions if they brought them, or we've actually had some where it's been mostly just here are 2 or 3 pictures of my house and I want to talk to you about what I want to do. Can we just have a frank conversation about that? Obviously, the more that someone comes with, the more feedback they might get from some of our members who, are obviously particularly architects who are going to be able to really lay into things that they're given designs. But we've had very productive conversations with going from full-scale developers looking to do massive projects to individual homeowners seeking to make changes to their home. I think in particular of a house in Langley Falls that has come to us several times for workshop sessions with merely just hand drawings of the zone, and wanting to hear our thoughts before we ever sought an official ARB review. So we want to make this process as flexible as possible in the workshop session. And obviously, you're raising a question that eventually we'll have to have an answer to of how do we reconcile how Hollin Hills has handled its current review process with the current ARB process. And that's something that will definitely need to be reconciled. Additionally, during an action item, we actually seek public comment on it before the ARB takes a vote on it. So we actually ask if there's anyone in the audience that has any members of the public that wish to comment on those items at that time. In a workshop session, that is not a requirement. That is just a discussion with us and the future applicant on what they might be thinking.
But how do the applicants know about the fact that they should come to the ARB first?
Well, the hope would be, and that's part of the reason why we are doing the updates to our design guidelines, is making those materials as informative as possible, so that a person who would be seeking this would know that. Obviously, if you end up residing in HOD, it becomes something that an applicant, someone who is there, knows that's a requirement on them. if there were ever an HOD for Hollin Hills, there would need to be an educational component put on that. Thankfully, though, Hollin Hills already has a method that it has been doing that. So I think it would be more transitioning that type of communication to owners to understand how could you seek these resources in advance. So a lot of that's communication, and that would be something that, as a member of the ARB, I would want it to be done as early as possible, because I will be honest, the sessions I hate are the ones where I have an applicant who is coming for the first time and is unprepared to bring up their project or has not been able to seek us. And it's not because they're not trying, but because they've been uninformed about what they're coming into. I don't want to be the person of no, but I also don't want to be, easy street either. So that's kind of the challenge. And so we try to always work with those applicants when we see that happen, saying, well, let's defer your discussion and make it a workshop item so we can actually talk about it in detail. But I think education and communication is going to be one of the solving points for that one.
You're not normally working with a community that has a design review board of its own, I think. And so my question, I guess, would be, is it reasonable to try to integrate the requirement to go to our design review committee first before they come to you to make your life easier and the homeowner's life easier?
It is, as we've talked about before, the design review committee, and I have a slide on that later on for further discussion, but the design review committee is a process outside of the county process.
Yeah.
So the design review committee would have to determine how they would like to work with the ARB.
Okay.
We cannot take into account the DRC's. It would be helpful if we had it, but the ARB would make an independent decision. And I have an example later on. I was going to talk about Reston Association and how they go through the process. So
I was going to say, Laura, I was wondering if you had an example involving either Reston Association, and that's another reason why I point out the public comment opportunity too, is we've had individuals and organizations provide their comments on proposed applications to the ARB for our consideration as we go through our review process. That can be as simple as a homeowner or another member of the public sending something into staff, or as much as them saying something at a meeting, or as an entire entity sending a letter to us regarding a particular project. Many times these are new developments, so we have interested groups that want to make sure the ARB knows their thoughts on the proposed development as well. But Laura is right. We are an independent entity, so we couldn't integrate those activities. But what I will say is I would love to see informed submissions to us. That would be helpful always.
Okay, thank you.
Hey, thank you.
I could just add something in right just here. The DRC, as it is presently set up, we also encourage applicants or homeowners, if they have a complicated project, to come to the DRC early on in the project and get our feedback. And more people are doing that. As a matter of fact, I'm the present chair of the DRC, and there has been almost a sea change in that I am finding that more and more homeowners, when they first buy their homes, are now moving in, and one of the first things they do is contact the DRC. And they say, we think that we're going to want to add a room or a deck or whatever comes to their mind. Can you tell us what we have to do? And that never used to happen. So the people who are moving into these communities are more aware of the rules. In fact, very often they've decided to move to Hollin Hills because of our design review process. But we too workshop. We ask people, please come to us, show us your sketches, your ideas, let us talk to you about them before you spend a lot of money on an architect. And then after, even bring your architect to the meeting, and so that we can, talk to him as well. And then when it comes to us for a final review, that's when we say we want to see really detailed plans. We want to see what the materials are. We never comment on color. That is a long-standing Hollin Hills rule of 70 years. But, the materials that are going to be used, we want to see cut sheets. We want to see all that kind of thing in a final presentation to the DRC. So much of the stuff that somebody would have to put together for the DRC would be is required by the ARB. I don't see you all asking for anything that the DRC does not now ask for. And we also seek we also say to people affirmatively, you must notify your neighbors and other people who are going to see this project. And if they have anything to say, we want to hear about it. So we get all of that type of feedback as well. And then before we make a final decision.
Well, and this is Mike McGill. The DRC also says if your proposal requires a county permit.
That they have to go through the permit process, right?
Absolutely. We have always told people, we've got our requirements. You need to go, but if this thing is not going to stand up on its own, you need to be talking to the people in the county. We're not going to opine as to, whether or not it meets the building code requirements. So
that's
the thing we're looking for, and that we really would like to put our heads together with the county, is how to make sure that the two processes are not burdensome for the homeowner. I mean, we have a very good website now. We can post anything you want to post about the HOD process. We can put it on the website. We've just refurbished what we're saying about the DRC process. We're in the process of redoing that. So we can educate. I'm not concerned about that. We have much better ways of doing it now than we had even 10 years ago. But what we really need to put our heads together with the county is a way of making this work. And Laura, you mentioned, and Chris, the Reston Homeowners Association. And I'd be very interested to hear what they do and how it works for them.
Yeah, that's what I have a slide on that. I mean, I know it's fine. We can talk about it now too. But so basically that, the county process, this is all in the zoning ordinance and how this is laid out. So there's some bylaw items in the ARB bylaws that we could modify, but the stuff in the zoning ordinance, we can't change that procedure. We can't change we can't change much of what the submission requirements would be. We'd have to go through a zoning ordinance amendment or modifications to the entire zoning ordinance. So if we wanted provisions that specifically related to Hollin Hills, that would be what would go in the zoning ordinance section specifically related to Hollin Hills. So we've talked about that before. If we wanted to regulate fences, which we decided we didn't want to, that's where that would come in. The place where we can have a large amount of negotiation is in the design guidelines and how strict those would be. And that's where I think if the procedures are kind of parallel each other, that's fine. But I don't know, to be honest, how the exact Reston Association process works. I think I did it one time that one of my projects went to Reston Association. But it's a concurrent review, and the process kind of parallels, and then they get Reston Association gets the review, and then it goes back to zoning. I've done it with zoning cases only. I haven't done it with the historical overlay district out there. But they kind of the Reston Association, the applicant has to go to Reston Association, but it's not a requirement, but the applicant goes to Reston Association before they go through the approval and zoning. So they don't have at the end the process you're talking about of one approving it and then not being conformance with the Reston Association guidelines. But it's a process outside of the county process. So it's a little bit, we can't require that they go to the DRC or anything like that.
Laura,
yeah.
So obviously I have not been part of these individual meetings, but it would seem to me, as Laura's pointed out, that the ARB can't mandate the things beyond our ability and control. However, if things come to us showing that there has been thoughtful consideration given in by an applicant, those are things that we're going to take into account. And I think it would be valuable to draw the connections between the similarities between the two reviews, because I think it does make it easier for any individual submitting something. If they're preparing something for one as a requirement, then it should be ideally easy if it's the same thing that would come to us. And from what I'm hearing and from what I've seen given in staff reports and staff updates to us about how this process is progressing, there's a lot of similarity and overlay there. And I would want to foster that as much as possible so that when something comes to the ARB, if this is an HOD eventually, it would be very easy to give approval if it's already gone through that series of processes. Recognizing that obviously that's not us lending our authority over to the other, but I would want that to work in tandem and with each other. Those processes opposing each other doesn't make much sense.
This is Ron McCallum again. Can you hear me? I thought what Chris just said was really something that we've been looking for to hear for a very long time. It seems to me that if the ARB is willing to work with material that has been thoughtful, that they would factor that in their brains, even though they're processing matters under a different requirement, a legal requirement. Just a comment. Thank you.
I have a comment as well. My comment, Chris, are you there? Is the mic on?
Yes, I'm here.
Okay, you are aware that the Civic Association and the Civic Associations Committee that they call the DRC are voluntary. Okay, homeowners, there are no requirements for homeowners. And you use that word several times. Okay, I just want to clarify that they are voluntary associations. They are not an HOA. There is no contract. They are not owner agents.
Understood. And again, that is why it is only information that the ARB could take into account. It is not something, that's why we would not lend our authority onto it. And this happens in many applications we get before the Architecture Review Board, that we've sometimes had conflicting views from members of the public on projects, and the ARB balances that information, and that is why the board's membership is designed to be made up of professionals across the preservation field so that we can make an informed decision weighing all that information. But I appreciate you clarifying that, though, because I have not been a player in these conversations moving forward or in the past. And so it's always helpful to know, considering how big our county is and how much we have going on in it.
Yep. Thank you, sir.
Are there any other comments on this? And we can always circle back. I'll keep going. See if I can. There we go. All right, so this is that second kind of admin part that we do, that once the ARB approves a building permit or makes a recommendation on a site plan, it comes back to our group to ensure that that it's in conformance with what the ARB approved because of those changes that you've talked about. So if something happens after that, engineering happens and they need to modify something or change materials or change the height, staff makes a determination on whether or not it's in conformance with the ARB approval. Now, they have to be very minor changes. It can't be anything major, changing of massing, things like that. Those are all major changes that we have to go back. But we're just checking for conformance to make sure. Sometimes they submit the same thing with the ARB approval stamp on it, and that's very helpful for me because I know that that's the same thing that we have and I don't have to check. But other times, if there are some modifications or changes after the ARB approval, we make sure that they're agreeable to what the ARB approved. And also those conditional approvals like the material checks or color or size or whatever those outstanding things were, we check to make sure those are followed up on as well. So we coordinate that review with the site plan or building permit group, and then we do the sign off in our administrative record, which is FIDO, and then we put it in our file system for the permanent record. And then just a note that the ARB reviews and motions are valid for 2 years after the date of decision. So you don't want to start something that you've got 5 years down the road, hopefully. And we've had a couple times we've had to have people come back and do a reapproval for those. Any comments or questions on that one? Okay, and then just the last one is the normal issuance of the building permit site plan. So once they go through all the reviews through the county, the safety checks, final inspections, our reviews, engineering reviews, zoning reviews, the building permit is issued or the site plan is approved, and the process moves forward. So that was a general, before we go to the case study, I know that was very, we talked through a lot of that, but I thought it'd be helpful to give an example of kind of the discussion that went through, take you step by step through one of the cases that we had a little while ago. And this one was in the Centerville Historic Overlay District, which is on the other end of the county, but it was the Utterback House in the Centerville district, and it was a contributing structure to the Historic Overlay District. As you can see, it's a preschool, and what they were proposing to do was to change the deck flooring on the front where that white railing is, but just the flooring of it. And it's a child care center. So what they wanted to do was they had this, I'm sorry, these pictures are so grainy. I didn't have the hard copies with me. But the applicant submitted the permit request to the county. Their staff contacted us to determine if they needed to go to the ARB. So it was a yes, because it was an exterior modification to contributing structure that could also be seen from the roadway. So if we were doing examples that we talked about for the staff administrative review only, it would be general maintenance, things that didn't rise, repairs for exterior but not visible from a roadway or a historic structure. So it could have possibly even been an addition on the back and not visible for anything, but because of the fact that this was an interior modification to contributing structure, it had to go to review for the ARB. So this goes back to, I wanted to point out, this is when the design guidelines kind of come in play. We would ask the applicant to look at the design guidelines. And so it talks about the Secretary of Interior Standard 6. These are the design guidelines about repaired rather than replaced if possible. But if the severity of deterioration requires replacement or distinctive feature, the feature shall match olden design, color, texture, or other visual qualities. And then the design guidelines go on at another point to talk about what the kind of materials wood was used in this area, and then avoid using materials and elements that are incompatible with the historic district. So that's kind of what happened. So then when we went to the ARB, the applicant proposed using wood or Trex for the Trex materials for the deck replacement. And the discussion ensued with is the framing of the deck, could that be used with the Trex material? What would it look like? The size, the width, the color of the Trex material. And the ARB guidelines recommended that traditional construction material be preferred. However, it would be hard to replicate what was there. And Trex only came in one size. So then the ARB, weighed the decision, and they ultimately ended up approving it with the condition that the edge of the decking material, which could be Trex or wood, would not be visible to the public. So while the design guidelines didn't specifically call out the Trex material, ARB said, okay, this is in conformance with what we're looking for. If the wood is not a feasible replacement because of X, Y, and Z, that there are other materials that can be used. So I thought that was a helpful example in talking about the different decking that was going on with the additions and design guidelines last week. Does anyone have any questions about that? I know kind of ripped through it very quickly, but just kind of the steps and processes and discussion that went through. Okay. So Chris, I don't know if you had anything to add on that one, but that was just kind of a quick, or if anyone had any questions about.
I'd add that each time we have an application to the ARB, each one is special. There's no cookie cutter situation in which someone say, well, this was what someone did for this other example, and it's always guaranteed that you'll give me an approval. There's definitely something that the ARB has tried not to, treat things in that manner. We want to look at the individual property that's being affected, the materials being suggested, and the constraints placed on the use of the property as well. So there were a lot of factors to weigh in the example that Laura last gave. I will say we've looked at other deck replacement projects in that same overlay district, and some going to do the entire deck being replaced with Trex and other materials. And we've gone back to we would prefer it all be wood, and that we've been able to get the applicant to make those changes, recognizing that that is the appropriate material consistent with those standards. But it's something that discussion happened over, I believe it was 2 meetings, was it not, or was it a single meeting we were able to solve that in, Laura? I cannot recall. You're muted, however.
I don't remember how many, but there was a lot of discussion on the Trex versus wood.
That was part of the benefit of having the architects on our board, because several of them had experience with the material and could speak to the different types of constraints or limitations placed on it, so that we could then decide, was this appropriate, or could we limit it to a certain area and then provide appropriate framing or covering around it to ensure that it wasn't in the public view.
Okay, this might, Miguel, I've got a question. When I was chairman of the DRC, we had an applicant come in and say that they wanted to replace their existing T111 siding, which they felt did not have the degree of permanency and economic attractiveness as alternatives. And they wanted to use a cement-based siding, and I don't remember the name of the cement-based siding. I never heard of it before. We didn't let them do that, but their argument was that the T111 siding was easily deteriorated, and they wanted a more permanent and more affordable alternative. So would that be something the ARB would consider approving?
I'm not going to give an ad hoc approval or denial one way or another, but what I would say is when we go to those standards, the first rule is to replace in kind if we have to replace something. So if the material is deteriorated in a way that's not serving its purpose anymore, then the first statement is, can we replace it with the same in kind identical material? That could be wood, that could be metal, that could be plastic, whatever that original material is, that's going to be my initial assessment. And then we're going to need to talk about why if the answer is no. We've had similar questions come up with sheet roofing for several buildings that the county operates, and that certain styles are no longer made. And because they're no longer made, because the company that made them is no longer in existence, can we find one that is similar to, in a way that replicates it in almost every way, except for perhaps some minor details. That would be the next step up. But there would need to be a lengthy discussion, at least from my perspective as a preservationist, before we would ever get to something of saying, in my opinion, we would ever accept a replacement material. That's my general opinion, since I can't speak for all my ARB members, but I can pretty much indicate that most of the architects on the board would also agree that the standards say in kind first. Then we work our way out. Or I don't know if you had anything to add, or Elise, or Kate. Obviously, I know I have other ARB members, but that's
Could I just follow this up a little bit more? Let's say you have a deck on a house. The original house was built in just for me to understand how the thought of preserving the historical house works. You have the original house is built, let's say, in 1958. It did not include a deck. Homeowner sometime in the 1990s decides to put a deck on the house. Comes to the DRC, gets approval for the deck. Now it's 25 years later, and the deck, which was built in 1992, is now deteriorating, and the homeowner comes back and says, I want to upgrade the material used for this on my deck because it has to be rebuilt because it's falling apart. Now, many people who come to the DRC in that situation say there's new materials that are available. They're better, they last. They don't put wood splinters in our children's feet and things like that. And this deck that was built in 1992 was not really part of the original historical building. So is it important to you that the 1992 deck be preserved, or does it make it easier at that point to say, well, consider new materials?
Barbara, to that point, the trucks in the child care center, that was something that was taken into account because the deck, I think, was built in 1976 and the original house was built in the early 1900s. So that did come into concern and account because we decided, okay, well, that part of it doesn't meet with the significance of the district. Therefore, should we allow this other materials? And it also, like you said, came into account where the wood would be splintered. The kids played out on the porch and it wasn't appropriate material for the use of the structure. So do we want to preserve the structure and the use that's in it, keeping it occupied and standing as opposed to, how else are we going to deal with this? So those two things definitely do come up, and they came up in this example, and thank you for calling them out, but those questions do come up, and that's why Chris was saying every property is looked at differently and uniquely for what it's being used for.
Laura, I won't necessarily comment on the exact example, but I'll say when you deal with additions, the first thing you're looking at is compatibility, because we're always focusing on the historic property. We're dealing with anything reviewing related to historic properties. We want to see, is there compatibility, and can we bring that into closer compatibility would be a question too, because we don't want something that is going to cause further damage to the integrity of the property. But we also aren't there to nuance out something that is not a contributing aspect. So it is possible for additions to become historic in and of themselves, too, I'll point out. So the ARB has to weigh all those factors. And additions are probably the most complicated ones because they require a lot of consideration of, well, if it's an existing addition, how well was it done originally? Are there ways that it could have been done better? How can the board help inform that in a way that is benefiting the property and the HOD is where the focus is. Obviously, we do weigh into account the uses of the property too, as Laura pointed out. And since the board is charged with helping further the use and preservation of its properties, we want to keep that in mind, particularly when the property, an example, was being used for a daycare, not an individual homeowner's residence. Sorry if that's a non-answer, but I will acknowledge I am a federal employee, so I'm pretty good at those.
Chris, I want to ask you a question about this.
Absolutely.
To my observation, and it's perhaps just my opinion, but it seems to me we're moving. There are trends going on in our neighborhood, in our greater community, and one of the trends is to either pave or use concrete or use pattern concrete for driveways. Okay, people are upgrading what used to be gravel or ground driveways. And there's enough of them in my observation to say that it's a trend. And it's, in my opinion, a very attractive trend that falls into the idea of Hollin Hills being experimental in modern design and going forward in modern design. What's your thought on that?
I'll comment that I'm not a landscape architect.
Steer people back?
Preservation is always a challenging field because you don't want to create what we call the bell jar effect, where you trap something in a bell jar and it dies. But you also don't want to do something that allows that what we are trying to preserve to degrade in a way that is no longer recognizable. So I would have to go back and look in this instance of Hollin Hills of what are the contributing features? What are the aspects that make it eligible for the National Register? What are the things that make it significant? And I would be heavily deferring to our landscape architect, since that does drift into the landscape materials, not just architecture and architectural history. But that districts do evolve over time. I will give that fair concession that there have been trends throughout large historic districts, that there are trends in building designs and landscape designs. And so a well-written nomination, a well-written study on a district will recognize all those trends and allow me and my other board members to interpret it in a way that says, yes, this does seem compatible, or no, yes, we understand innovation is something, but this is going beyond that.
And it's also the justification, Lee, in that example of why you need the paved driveway. Do you need it because shoveling, I always go back to the ADA accommodations, like that type of thing. If you need to put a ramp in, you need to prove why, you need to convince us why you need the ramp and why it's needed, and then we take into the design guidelines into concern with that as well. So we need a good justification for the change, and then how we can mitigate that change to make it in keeping with the design characteristics of the district.
Thank you.
Thank you. I think I heard someone else pipe up. No? Okay. The last thing was about the resident association, and I know we already talked about that a little bit, and I'm happy to talk further about it. But I have the resident association website on this slide, but from my experience with the resident association, as we talked about a little bit before, it's a concurrent process, but they're not necessarily dependent on each other. And that's the resident association dealing with zoning cases. So, for example, what I've seen is the applicant usually goes through the zoning review first and gets it pretty much close to done, and then goes to the resident association to get some comments, and sometimes it has to come back to the zoning review if something majorly changes in one of them. But usually it's kind of just a formality and a review of, to make sure there's buy-in from the community, but that's not something that the Board of Supervisors would necessarily take into account. So that's a very similar situation to what this would be. So,
Laura?
Yes.
I apologize, but I have to do bedtime
No,
for my
that's fine.
3-year-old.
Go ahead. I think we're pretty much done.
So I didn't want to just drop off the call. I appreciate everyone for allowing me a chance to talk about the ARB, and I am excited to see where this process takes everything. Win, lose, or draw, whatever the outcome is, and I'm glad that you all gave me a chance to provide the ARB's perspective on it. So thank you for having me.
Thanks, Chris. Appreciate your time. And if you had any other questions, you can field them through Elise or Kay, or I can forward them on to Chris if we had any other questions about the Architectural Review Board process. But I'm hoping that I'm happy to open the floor to any comments or concerns. I would ask if we have design guidelines comments to hold them for the next meeting, because I want to make sure our consultants are here, and I want to make sure I can relay them correctly and accurately. And that we'll have another draft to you before the next meeting with modifications and changes. So wanted to let you know that's on its way, and that I hope that the process tonight gave you a little bit more of an overview of the ARB and kind of a step-by-step procedure of how this would affect you if the Historic Overlay District was adopted. So just putting out the next timeline, tonight's November 2nd, we're here now. The next meeting is November 16th, and we'll be talking about the design guidelines for the majority of that meeting and or other discussion topic items. And then the meeting after that we have slated is for December 7th, which is also a Monday. And then we're looking at having a community meeting with additional outreach in January or February of next year. And at this point, we're still intending for it to be virtual unless something changes, but to be determined. But then at that point, we'll hopefully have a better direction of where we're going. But the goal is to have the design guidelines in pretty good shape. And we can have additional work group meetings in January and February if needed. But I want to make sure that we have the design guidelines and at least some sort of support and or have at least the ideas of the things we need to work on before we go to the community meeting, because I want to be able to come out of the community meeting with a clear idea of where this project is going and what we're looking for. So yeah, so if there's any questions or comments, happy to take them. It's only 8:20, so I'll be around till 9, but happy to take comments or concerns now.
Laura?
Yes.
I just have a clarification. Yeah. When you first started to speak about the overview of the ARB procedures, you said that from start to finish, I think I heard you say, it's about a 5 to 6 month process. Did I hear right?
No. Mm-mm. No.
Yeah.
At the beginning, the beginning to the end of the ARB, and I apologize if I said that. So the ARB is it meets once a month, and so conceivably you have to submit your items 2 weeks ahead of time. So if you knew you were coming to us, you would submit your items, come for a workshop and or an action item, so maybe 2.5 months, depending on how quickly you would get through the process. So if you needed to come to the ARB twice, then it would be 2 months, but not 5 to 6 months.
Did you also say that, maybe I'm confused on this too, you have to submit a permit to Fairfax County generally, even if you know you're in an HOD first?
So usually, so it will come to me one of two ways. Either it gets submitted to building permits first and they don't know they're in a HOD, and it gets flagged by our GIS computer system and mapping system and says, hey, you're in an HOD, and then they'll send it up to me for review. Or if you know you're in an HOD, you'll come to me first and say, hey, and that's where Chris was talking about the workshop items was, I've got this idea I want to do. Can we do this? I don't want to go all the way and spend all this money if I don't want to have it happen. But then at some point you will have to submit a building permit through the normal process of the county system.
Now, the 2 to 3 months, just to clarify, it assumes that everything goes smoothly, that you don't have to go back to the ARB. Because the one meeting I went to, someone was coming for the 3rd time. Correct.
Yes, that's assuming everything goes. It's assuming everything goes smoothly, and that was the case too, where the gentleman didn't have his idea completely fleshed out when he had come. So it would have benefited him to come to workshops prior to that. But yeah, it could be long and drawn out, but we try. That's the exception, not the norm.
Okay, thank you.
Laura, I've got a question. This is Mike McGill. This is not exactly directly connected to all that you've discussed, but in the early part of your presentation, you talked about what permits are required. And is it true that you cannot demolish a house in Fairfax County without a permit?
If you get the permit, right? I mean, you can, in order to demolish it and build something new, you would have to get a demolition permit before it could be torn down.
So you can't just, come in and say, I'm demolishing this house and then I'll go for the permit to replace it.
No.
Okay, thank you.
You can do them together, but you can't just do it and then, you should. I mean, there's people that don't get permits all the time, but you should be getting a demolition permit before it's torn down.
Yes, we do.
Well, so what if there's a demolition underway without a permit? How does one stop it?
You would report it to the county and they would put a stop work order on it. That's a code compliance thing, because then they're not following the county regulations and procedures. And that involves the whole legal matter and elevating it to the county attorney and things like that. But if you find that they're demolishing something that doesn't have a permit for demolition, then that would be a violation of the building permit code.
Thank you.
Well, if you, I'll be here for a little bit longer, but if anybody had any questions, if not, thank you all for your time and I appreciate it. And if there's something that you feel we need clarification on, like Lee, I'm working on your question, that please let me know and we can bring it up for the larger discussion at another meeting if needed. But I'm happy to field those questions. So thank you all for your time. Please be in touch and take care.
Thank you.
Thank you.
Sorry.
Did somebody say my name or say thank you?
Just to say thanks.
Oh, okay.
Laura, I've been having trouble with WebEx tonight. In fact, it's not even letting
You and
me
me
sign
both.
out. It's not letting me leave.
It's
So
not
I'm
letting
gonna
you leave the event.
For example, I can't chat. And I just suggested to Ann Stuntz at the History Commission Institute of Policy, if you have to sign up via chat to talk. So
Right.
I'm gonna get out of WebEx and come back in. And it's just to check things out. Restart my computer.
Sure, we'll wait here. Yeah, just if you want, do you want us to wait here? I can just leave
Well,
it running.
You said you were sticking around till 9, didn't you?
Yeah, I am. But if nobody was
Well,
here, then I wasn't going to stay.
Actually, if I'm not back on by 8:30, go.
Okay, that's fine. That's fine. I just wasn't going to hang around till 9 if somebody.
But the exit menu doesn't show. It says cancel and nothing else. It says, do you want to leave? And
There's no X at the
there's
bottom
no
of your
yes
screen.
box.
Okay, I will say too. They upgraded.
I hit the X.
Go ahead.
You hit the big red X.
I hit the big red X. You want to leave the event, and the only thing that I have on the